Good afternoon, good morning, good evening to everybody, depending on where you're located in the world. And I see some familiar names in the participants. So hello, everyone. My name is Émilie Max. I work as a researcher at the Geneva Academy of International Humanitarian Law and Human Rights. And it is my pleasure to be hosting this virtual book launch of the second edition of The Occupation of Justice. We have with us tonight, we have 5 very distinguished panelists who I will introduce in no particular order of importance. First of all, we have the 2 authors of the volume, David Kretzmer, who is a Bruce Wayne Emeritus Professor of International Law at the Hebrew University of Jerusalem, and Yäel Ronen, who is a Professor of International Law at the Academic Center for Science and Law, a Research Fellow at the Minerva Center for Human Rights at the Hebrew University of Jerusalem, and the Academic Editor of the Israel Law Review. We then have Liron Libman, who is a retired colonel and the former head of international law at the Israeli Defense Force. We have Shlomi Zachari, who is a lawyer practicing in Israel. And then Yutaka Arai, who is a professor of law at the University of Kent and the Brussels School of International Studies. The way tonight will work is that first we'll have David and Yäel present the book briefly. Then the commenters will go in the following order. First, Yutaka, then Shlomi, and then Liron. Each of them will have about 15 minutes for their presentation. And then we'll give the authors the possibility to respond and react to the comments. And we will use the remainder of the time for interaction with you, the audience. You're muted and we cannot see you, but please feel free to use the chat feature to ask questions to our panelists, authors, and commenters alike. I will take the questions in a first come, first served basis. And if they address similar topics, I will group them in clusters. So without further ado, I will give the floor to you, David.
Thank you very much. And good afternoon, good evening, good morning to everybody listening in. And first of all, thank you very much for Emily for organizing this and for Yasmin for doing all the technical work involved. The jurisprudence of the Supreme Court relating to the occupied territories is an interesting subject, and I decided to address this first 20 years ago when I wrote the first edition of the book. The very idea of judicial review by a national court of the occupying power over acts of the military forces in occupied territory was regarded in 1967 as a precedent, as a unique case which had not been attempted before. And there are many aspects which actually typify the Israeli situation and which led me to devote a whole study just to the Supreme Court and its decisions relating to the occupied territories. First and foremost, and this is an important point, is the actual ambivalence of all the Israeli governments which have been in power since 1967, the date that Israel gained control over the West Bank, and Israel during the 1967 war. The ambivalence to the territories as occupied territory. So on the one hand, when they came before their own Supreme Court and were forced to defend the actions of the military or other authorities in the occupied territories, they generally try to defend the actions on the basis of the customary law of belligerent occupation. But on the other hand, in actually managing those territories, many of the policies and practices of the Israeli governments were not compatible with the generally recognized principles of a regime of belligerent occupation. The prime example is the example of the establishment of Israeli settlements in the occupied territories. And this placed the Supreme Court in a difficult position. And what we examine in the book is how the Supreme Court has tried to manage such a situation. And it has managed it in certain ways. First of all, the big question, and I still regard the big question, is the question of settlements and the use of public land and sometimes seizing of private land for those settlements. which is largely regarded as incompatible with the law of occupation, is a question which the Supreme Court has done everything that it can to avoid. It is decided very early on that the very legality of the settlements is a question which is regarded as non-justiciable, not a question for the court to decide. It's left it open. And it must be made clear that while the court has never said that the settlements are as such unlawful, on the other hand, it has never said as such that they are lawful. And now this has placed it in a very difficult position, which has compromised its stand in many other cases. Since 1967, the court has decided thousands of cases relating to the occupied territories. We are fortunate to have with us today Shlomi Zacharia, who's actually represented Palestinian petitioners in many of these cases, and he has a view of the court and can have a view of the court from a person who's argued those cases before the court. Now, much has happened in the 20 years that has passed since the first edition, and I was fortunate to have Yäel join me to write a second edition in which we have many chapters which were not relevant in the first edition, such as the construction of the wall or the separation barrier between the West Bank or in the West Bank, and the question of judicial review of hostilities. I will not go into details about the questions we dealt with. I will just mention in 2 sentences what our main conclusions are. And we have a whole section of the book devoted to the conclusions. And first of all, our conclusions in the second edition are not that different from the conclusions that I reached in the first edition. And that is that, first of all, when it regards major Israeli practices or policies, the court has either avoided judging those or deciding whether they're legal or not, or has granted them absolute legitimization. The examples are deportation of protected persons from the occupied territories and punitive demolition of houses. On the other hand, in certain cases, in quite a lot of cases, the Supreme Court has been a forum where individuals can get some kind of remedy against the military authorities, sometimes by a judgment of the court, more often by a deal reached within the shadow of the court, either because of pressure by the judges or because the authorities decide to settle the case rather than to have the case decided by the court. I will leave it there. That's my 5 minutes and hand over to Yäel.
Thank you, David. Yäel, after you.
Okay, hi everybody, and again, thank you, Emily, thank you, Yasmin, thank you for the commentators who agreed to participate in this event. Let me start by a tribute to the late James Crawford, who was my PhD supervisor. And one of the first things he said to us was that a good thesis is one that you can write on a postcard and send to your grandmother. Now, even when he said that, I don't think anybody was using postcards anymore, but I guess the equivalent of that is 2 minutes on Zoom. I'm actually quite fortunate because I had prepared a bit more, but since David has already covered some of the things that I wanted to say, let me just pick it up there and go a little further. First of all, picking up on the point that the main finding being that invariably, the court upholds the policies and practices of the government and the military authorities, even if in certain cases it provides remedies, but those remedies are based on accepting or not dealing with the legitimacy and the legality of the policy itself. It takes the policy as a given, and within that makes little tweaks here and there. Now, I think it's important to point that one might argue, well, perhaps these policies and practices are lawful, and therefore there's no problem in upholding them. And I think one of the important points that we make in the book is that in order to reach these conclusions of upholding policies, the court has to do a lot of legal acrobatics. There's a lot of disregard of international law where international law should apply, and specifically the law of occupation. And sometimes there's misuse of the law of occupation. And in fact, I think if one of the things that is very apparent and this is one of the places where there is a distinction or the difference, there's somewhat of a difference between the first and the second edition, other than it's not just more of the same, is that the court has increasingly been applying different legal regimes than the law of occupation. Now it does that half-heartedly maybe, but it's still, it's moving away from the law of occupation towards sometimes flirting with international human rights law, but mostly Israeli administrative law and constitutional law. Now, administrative law has always been there, but it's become a lot more prominent now than in earlier decisions. Now, picking up on the fact that the main issue that informs and drives a lot of the problematic decisions is the settlement project, I want to add not just the decisions on the settlements themselves, the fact that the court decided not to discuss the legality and hold them as institutionally injusticiable, where ordinarily the court does not consider issues to be injusticiable, but the policies relating to the settlements inform a lot of other issues that are not directly related to the word settlement does not necessarily appear in the decision, but it's clear that it's in the background. Obviously, one of the issues is the main issues is the separation barrier, which originally was for the protection of Israel and its citizens. And the question is, well, citizens within Israel, citizens outside Israel, is it also intended to protect the settlements? And the answer is obviously yes. Another issue is planning and building, where the court has accepted, and again, it's usually the passivity of the court that is the issue, has accepted the fact that Israel applies different policies in terms of priorities in planning and building for Israelis and for Palestinians. Again, with the construction of the settlement being the implicit driving force below this. Another issue is the status of Israelis that the court has recognized as part of the population of the West Bank, not as protected persons, but as part of the local population, but has not taken this as far as the implications of being part of that population is. And finally, the court has accepted the application, and I want to be careful about this, but has not spoken out against the application of different legal systems within the same territory based on nationality for Israelis and Palestinians. Now, I want to say something about what does this say about the court and what this says about the territories. So the question is, would a different domestic court have acted differently? Now, it's a hypothetical because we don't know of any other courts that for 50 years have been adjudicating cases on occupied territories. And the fact that the court does that, I think, is to its credit. However, we do think that given what we know about domestic courts, the court's conduct is actually quite typical, because any domestic court that seeks to maintain legitimacy within its domestic audience, and the audience is primarily domestic, is limited in its relations with the government. And that's true especially when dealing with international policy. Now, recently in Israel, the court is in a particularly precarious position, and therefore its power to restrain the government is even more limited. But another thing, and that is unique to the Israeli courts, and you don't see that with domestic courts so much with domestic courts in other countries, is the fact that the court is a political organ of an occupying power. And notwithstanding the original purpose of opening its doors to the Palestinians, at the end of the day, when there's a conflict between the court's own community and a foreign enemy population, it's difficult for the court to provide a strictly objective legal analysis. It's not neutral to state interests, and it does align itself with them. So what does this tell us about the status of the territories? So formally, the court maintains that the West Bank is occupied territory, and I'm sure there will be questions about this. We can get into that in the Q&A. But the regime that applies there in practice, with the court's implicit and sometimes explicit blessing, resembles a little bit of a colonial regime, and this is something that David has raised in the first edition. The population is subject to the restrictions of the law of occupation, but it doesn't benefit from the protections that the law of occupation provides either to individuals themselves or to their property. Now, the court did not create this situation, but the fact that it does not intervene in the policies and practices that make it up effectively legitimizes this situation. So let me stop here, and I'm looking forward to the comments of the commentator, and I'll be happy to answer questions and discuss later. Thank you.
No, thank you so much to the both of you for highlighting the main findings of the second edition, how it changes from the first, but also for putting the court back into its institutional and political or policy-related context in Israel. I think it's going to be very relevant for the sake of the discussion. Now we're turning to the commentators. So Yutaka, you have the floor. You're muted.
Okay.
No, now we can hear you.
Okay, thank you. First of all, thank you very much, Emily and Yasmina, and thank you very much, and Yäel and David, Professor Kretzman, and the panelists, and for this invitation. And this is a great opportunity. And thank you very much for all the participants. Now, I'm also just coincidentally I'm asked to write a book review for one journal with respect to this book. So it is very a good time that I'm actually would like to make a comment on some of aspects of the international law armed conflict, and also some comparative in the public law when the time permits. But first of all, I just want to make a quick disclaimer that I'm not able to read Hebrew or Arabic, so I'm not an expert in the public law of the Israeli jurisprudence. Okay, so that's the methodological hurdle that I'm actually faced with. And another aspect that I just want to mention is that this is a new edition of the book, which was published just 20 years ago, and it's quite remarkable that the volume and the chapters has just doubled. So it's now nearly about, the volume is more than 600 pages with the chapter from 10 to 20, and it has become a kind of a new kind of classic book, which I call kind of an instant kind of a classic, like Dostoevsky, I would say, in terms of the rigor of the analysis of the case law, of the modus operandi of the Israeli Supreme Court, confronted with the petitions arising from or in relation to the occupied territories. And as Yäel mentioned, I think much of the credit should be given to the fact that the Israeli Supreme Court is probably the only court, the only national court, that is dealing with the petitions and carrying out the judicial review over the petitions from the inhabitants of the occupied territories. Imagine that if we have any sort of international court of humanitarian law, okay, the issue that we can probably talk about in the Q&A, I think that would be very interesting. Perhaps the answer may be different from the perspective of the national court doing the judicial review, or even from the international monitoring bodies of the human rights law that are designed to apply only the human rights law, or perhaps the indirectly humanitarian law. So in that sense, I think it's very significant that the highest court of one jurisdiction is engaged within a rigorous analysis and well-reasoned analysis of the case law. Okay. However, the judicial self-restraint or various legal techniques have been implemented, as the authors have actually mentioned. These are just the preliminary remarks. Now, because of the sheer volumes and the extent of this book, which is again really a very impressive one, and it's a great the book it's a great instructive book, not only for international humanitarian lawyers, but also for international law in general, as well as comparative public law in general. Okay, I would like to just focus on just a small aspect, just a few selected topics of the law of occupation and the comparative public law. One aspect is the interpretation of Article 43 of the Hague Regulations that the court has dealt with. As the authors actually mentioned, one of the fundamental issues, of course, the court's consistent and steady refusal to rule on the legality of the settlement as such, and that is probably one of the fundamental obstacle, okay, to any progressive or any activist oriented measures that the court may have taken or may wish to take. The court has taken a rather very progressive measures when it comes to the cases related to the conduct of hostilities, including the, for instance, the requirement that the ex post facto examination must be not only conducted by the military authorities, even during the ongoing hostilities, but also the judicial review must intervene with respect to the such ex post facto examination. I think that's a very important aspect. And there is also another progressive element, like such as the right to provide certain minimum basic subsistence and medical goods, even during the active hostilities. Okay, as mentioned in the Al-Bassini case, for instance. And I think that's a very important progression. But that progressive tendency is unfortunately very much eclipsed by the considerable deference shown by the court to the executive's decisions. And what are the underlying rationale for that? And there are various legal techniques which has been used. And one of the legal techniques that has been used is precisely the one that the authors mentioned. It's the what's the authors call the contrived interpretation of the very relevant provisions of international law-bound conflict, namely Article 43 of the Hague Regulations and Article 49, Paragraph 1 and Paragraph 6 of the Geneva Fourth Convention. Now, with respect to Article 43, what is particularly striking is the way in which the court has interpreted and has, of course, included the rights of settlers and the rights as one of the variable dynamic variable against which the rights of Palestinians inhabitants in the occupied territories are juxtaposed. Okay. Now, this very much disturbs and perturbs the whole structural balance carefully crafted by the authors of the Hague Regulations and the law of occupation in general, because the law of occupation as such is a temporary administrative regime or temporary trusteeship regime to control the damage that may have been inflicted on the rights of the inhabitants. Okay, so in order to protect the vulnerable population of the civilian populations, the various very reinforced form of the rights and interests are guaranteed as a form of law of occupation. But the problem is that the Article 43 is a kind of a mini constitution of the law of occupation, which include the military necessity concept, the empêchement absolute, sauf empêchement absolute, unless absolutely prevented. Now, this is interpreted by the leading author, Schwenk, written during the Second World War as the equivalent to the concept of military necessity. And that becomes probably the mainstream interpretation. Now, but this original meaning of the absolute, empêchement absolute seems to be rather very narrow. Okay, I mean, and so, of course, it's not as narrow as any logistical military need, as we see in Article 52 of the Hague Regulations, for instance. But I think with respect to Article 43, inclusion of the settlers' rights as one of the countervailing interests against which the balance, against which the rights of the Palestinians needs to be opposed, is a one obstacle. And another aspect is that the fact that this concept of the duty or power of the occupying power to restore and ensure public order and security under Article 43 is interpreted in a manner correlative to the concept of the empêchement absolute or military necessity. As such, the concept of the empêchement absolute is widened by virtue of the broader meaning given to the concept of the public order and safety, ordre public et la vie. Now, ordre et la vie publique. I think that is a fundamental interpretive problem. Okay. And another aspect that I want to mention, I think the Israeli Supreme Court has not actually has not actually engaged in this interpretive technique so much. But some writers have actually argued that, for instance, even if a particular special limitation clause or escape valves that are used in a specific provisions, such as, for instance, the requisition, prohibition of requisition subject to the military needs of the occupying army under Article 52 of the Hague Regulations, that specific clause should also be read in the light of the general clause under Article 43, which also includes certain overarching balancing. Now, well, in terms of the legal interpretation, well, that may be perhaps, that might be considered reasonable, that may be reasonable. But I would say it's reasonable to the extent that it is kind of filling a gap. It's kind of a residual. The general clause should intervene with respect to the application of the specific provision, such as Article 52 or 53, only if the limitation clause already embedded, built in under those limitation clauses are considered as fully exhausted. Now, it should, the general limitation under the general clause of Article 43 should not be invited to operate in such a manner as to widen the restrictions already incorporated into the specific clause. I think that but that is my understanding, but that the Supreme Court decisions, according to the book, give the impression that it's the contrary. The general clause is actually used to, in fact, enlarge the restrictions already incorporated into the specific clause. Okay. Now that's, I think, sorry, Emily, I think we ran out of time. I've got several other comments, but I think probably I should probably cut it. Maybe I talked too much. Perhaps not.
No, do you want to make maybe one other comment?
The other aspect of that, well, maybe I should just leave it to the question or answer, maybe because there are several questions relating to more the Geneva Convention, Article 49. Well, the one thing that I just want to mention is perhaps also leave it to the question and answer for more further elaborate discussion. It's the interplay between the normative paradigm of occupation and the normative paradigm of hostilities. At what juncture can we actually envisage? And sometimes it's a kind of a mixture. In a kind of a, as Yäel Ronen says, it's kind of a functional manner. We need to take into account more functional application of the law of occupation, as in the case of the Gaza Strip, for instance. But also, to what extent the hostilities and regimes can be actually applied. You cannot actually clinically segregate the two regimes. Okay. Some provisions of the law of occupation already incorporate or envisage or contemplate situations of the military operations taking place. Take a look at the example of Article 53 of the Hague Regulation that make a reference to certain hostilities. The same applies to Article 53 of the GC4 on the destruction of property is prohibited, subject to the exception that unless there is a necessity, absolute necessity, pursuant to the military operations. So this is a very interesting aspect that I would like to explore, maybe with the authors and other panelists, yeah, or maybe with the participants as well. Thank you very much.
Thank you so much for your comments, and I think you raised two very interesting points. The first one is about Article 43 of Hague Regulation, which, as you rightfully said, is a mini constitution of occupation law, and the second one on the interplay between the paradigms of occupation and hostilities and how it's intertwined in the law itself, and can you really make a clear-cut separation. So I hope that this will trigger some engagement from the participants for the Q&A, but I also look forward to Yäel and David's reply. Now, without further ado, I'm going to give the floor to you, Shlomi. You're commenting on the second part of the book.
Thank you, Emily, for this kind invitation. And before I start, just some acknowledgements. Professor Kretzmer, I met you as a teacher 16 years ago. And I think it was in the last semester of my BA, after I took, I think, every course on international law and human rights law, and I'm sure that I know everything about it. And then we had this course with this very small name, human rights, was 4 hours in a row every Monday afternoon. And after the first class, I realized I know nothing about international law. I know nothing about human rights, and there is so much to learn. And thank you, Professor Kretzmer, for helping me to learn. It's been a huge journey for me that ended so far, but not for good, in the regularization bill when we all met in the Supreme Court hall, litigating against it. And thank you also, Yäel, in which I served as research and teaching assistant for 10 years. But for those of you who know Yäel, being research assistant to Yäel is nomination for life. You can't quit that. And every once in a while, I'm very happy to contribute to your researches as well to the book. After reading that, the book, so many cases that I was litigating appearing there. So at least you academics managed to benefit from all this paperwork. I've been asked to talk a little bit about what I'm practicing as a lawyer mainly, and this is the issues of land and people. Two major aspects that the Supreme Court during the last 40 or 50 years was dealing over and over. And these two issues taking, well, land, we're talking about which land, whose land is it anyway, and people, which people, because there are two classes or two groups in the area. One of them benefits a lot of privileges, that's the Israeli settlers, and the other, the Palestinians that reside in the West Bank and previously on the Gaza Strip, or even currently on the Gaza Strip, are not enjoying the same rights. And as one of the main argument that I've heard once by a very high-rank officials in the Ministry of Justice is that Israel has many claims regarding the land. Israel has no claim regarding the people that live there, and by that they mean the Palestinians. And that definition, that small definition, really struck me when I heard that 13 or 14 years ago. And but realizing and practicing it, and we view it more and more precise in that way. When we're talking about Israel claims regarding the land and what policies derive from that, and they're all based more or less, and Yäel, you were very delicate in your picking of words, I think, manipulating the law of occupation by the Supreme Court, as the first manipulators were the state in its response to all these decisions. But if we'll go all over, there are several types of claims regarding that. First, what calls security or security, and seizing land as part of Article 23 or as part of Article 46 of the Hague Regulations. At first was justified for security reasons. Later on, it was proved that these security reasons were just a cover-up for erecting new settlements. Alon Moreh was allegedly the last case where this tactic was used, but as it was discovered years after, this means was used in other cases, even after the Alon Moreh. Second phenomenon that we viewed in the last 20 years were the separation barrier cases. As you mentioned in your book, there are around 150 cases dealing with several roots of the, or several aspects deriving from the separation barriers. All in all, when you analyzing them, and there are several books analyzing it, like Shaul Ariely's, for example, the main goal that for the root was whether defending settlements or allowing the expansion of settlements. So even these cases that were in whether broad or narrow aspect of the security aspects were for the benefit of the settlement. second claim regarding the land can be derived from historical or religious aspects. In many cases, we view that putting East Jerusalem aside, we hear, even in court, even by the state attorney or the military advocate general when they appear in court, that Israel and Israelis has very historical and religious roots in specific areas. Therefore, they are entitled to access, ownership, and other types of possession of the land. Of course, these possessions start as historical or archaeological sites, but later on become into a big settlement, and that's after uncovering all these aspects, we view that main claim for the land is political, gaining more land as possible as a policy. It's sometimes deriving as a very vocal call for annexation of Area C, as we witnessed in the last couple of years, whether the Trump plan or other suggestion by the government of Israel to annex Area C in part or in a whole. But for historians, people who did it in the history of the occupation, we can view that there were maps even in the late 70s or the early 80s that more or less describe the West Bank as we view it today, 40 years later, as it was designated in the first place by the whether politicians or other people. But all these political, whether it's tacit annexation or a vocal annexation in the West Bank, it was just putting an anecdote. The occupation started in 1967. Only 2 years before that, in 1966, the military governance in Israel towards our Palestinian Arabs just ended. So the institution as a control institution over people from a specific region was already existed. It was very easy to transfer the mechanism from Israel into the West Bank. But then I go to into your book, David and Yäel, and your main argument that also exists 20 years ago is that on the one hand, the court allows many abuses of Palestinian rights, whether it's and property rights, privacy rights, other basic human rights. You mentioned the deportations, the house demolitions, even the erection of the settlements without examining the legality of them and all of these. But on the other hand, the court sometimes gave some judgment, whether a minor judgment or whether a judgment that became very famous and useful precedents for us lawyers in favor of the local population, local Palestinian population. But when we view the picture as a whole, even as figures, we view that the situation in the West Bank is mainly due to the backing judgments of the Supreme Court is now very hard to imagine I will not go into a political definitions, but even from a legal point of view, what's happening in the West Bank, even from figures, the number of settlements, the number of settlers, the number of roads and factories and the areas that are allocated only for the benefit of one type of population, it's remarkable. And this issue of discrimination, in which you wrote very briefly and not briefly, in very expanded way in your book, it depends on all areas of life. First, natural resources, as we view in the what called the quarries case, and that I was one of the litigators over there. During the last 53 years, there were more or less new 11 quarries erected, new quarries in the West Bank, all of them owned by Israelis or Israeli settlements. The misuse of the law of occupation regulations as described by the court in order to justify them was something that I was stunned at. I mean, the wording of Albert Camus from every time you saying that 2 + 2 is not 4, but you have to repeat that, and even know that this is the truth, that 2 + 2 is 4, even though the court says it's 5, it's still in the back of my mind. But even in some more other heretical aspects, like planning, like allocation of land in the regularization bill, court, if you noticed, the court noticed and even stated that the aspects of discrimination in almost every life regarding land and in the allocation between settlers and Palestinians, it was stunning. I mean, there were 99% of the so-called governmental land were allocated to settlers and only less than 1% to Palestinians in Area C. The planning is that Palestinians has no representation in this area, in these institutions, in the way to define their own life and their own legal regimes. And that leads me to what you are not supporting or not backing these theories of what's happening in the West Bank and describing it as an apartheid regime, but yet you are supporting that it is a colonial regime, as I view it. But one judgment that was given a month ago that regarding, sorry, Liron, if I'm trespassing to your area of discourse here, but judgment of HCJ 2189 on 20 regarding Hamad versus the military commander. This case is dealing with whether there is a need for a judge warrant when you want to have a search in a resident of the West Bank. As the petitioners, I was not one of the lawyer of the petitioner, but some of my colleagues were. They mentioned if they're in Israeli in the settlements, there is a need for a judge warrant before entering into the house and start research. And for Palestinians, there is no need. The military commander can do based on his assumptions and his judgment, get into the house. And the judgment saying that, well, the argument that there are different legal procedures regarding the matter deriving from the main fact that there are two groups there. Each one of them is subject to a different legal regime. So once there is a different legal regime, obviously the procedural aspects of this regime, like the searching, is inevitable to arriving. So it's the apples and oranges theory that was talked by the court, and if it is really starting to say, well, of course there are different people, there are different legal regimes on the issues. But as you notice, the court did notice the imbalance between the two types of people in the West Bank, whether in the Ziada case or in the regularization bill. But it was so far not only said as a statement, okay, we acknowledge that, but what is the solution? What can be done in order to provide Palestinians with more legal defense comparing to Israelis who are subject also to constitutional law and to international human rights law as Israelis, while Palestinians are not, according to the government of Israel. These questions remain unanswered. Dave, you mentioned both in your preface and in the book that there is this shadow court, what's called the mitigation behind the walls. Sometimes you file a petition because you hope that someone will get sense whether in the state attorney or in the militarian, will say, come on, everyone, please back off this policy or this order or whatever. Sometimes it does happen, sometimes it does work, and sometimes for such individual or community, it helps. But more and more we view that the court as an institution, the court's deterrence regarding the authorities in the West Bank is becoming weaker and weaker. You mentioned in your book the early warning judgment as an exception for a method in which the court intervened and said that, well, this cannot be done. Unfortunately, as we've witnessed time after time, this judgment, the army did not comply fully with the judgment, and that happened more and more, and obviously we don't know enough about this. Just to closing points before I'll end this my part, and it relates to the deterrence. If we'll go, and it's something that I investigated in the past, about what happened in the international legal community or in the international legal deterrence regarding the Supreme Court behavior. So we view a very interesting pattern. You mentioned, if I'm not mistaken, several landmark cases in the Supreme Court. First was the Public Committee Against Torture in Israel, a judgment that was given in 1999 regarding the interrogation. I find it interesting to see that the judgment was given in 1999, though all deliberations and discussions in the courts were ended in 1996. The judgment was given only a few weeks after Israel joined as a signature to the Rome Statute. And you can read between the lines of the Chief Justice Barak back then, how he relates to that supranational authority as a deterring force that might have an effect. We saw that again in the separation barrier, the Betzuri case that was given in 2004, only 9 days before the International Court of Justice issued its advisory opinion again regarding the separation barrier. Of course, these two cases were subject to a lot of seminars and articles, but you see that we could say that the international legal arena has its implications on the court back then. And the last instance was, of course, the regularization bill judgment that was given in 2020 regarding another policy, a wide range policy to take over Palestinian lands for the benefit of Palestinians. And again, it was while in the shadows of this judgment and proceeding was the ICC prosecutor decision whether to start investigation or not. And all these signals that there is an international legal deterrence that is now more vivid than it used to. And when I read the first edition of the book 20 or 16 years ago, I was just start practicing lawyer. I say, well, now everything's going to change. I mean, all these first Intifada cases, all these politicized issues that the court was trying to avoid, now due to the new legal discourse, all this, it's going to change. I was naive in some cases, but in some cases, I think that this international aspect still serves as a deterring power. Though the concluding remarks of the book is not very optimistic. I mean, it is possible to gain some small victories, but regarding policies, it's very hard to change. Many times I've been asked as a lawyer, why are you doing this and what are you expecting to receive by it? So first and foremost, and I think both Yäel and Dave will agree, we provide databases for you academics for your writings, and I think this is the most important thing for us lawyers to do. But seriously, if we get into individual gains that I mentioned, whether direct or indirect, or even if we as human rights lawyers, someone who are trying to challenge the occupation itself and the court, we help to draw the historical aspects of this area and the judicial history of international law in domestic court. And there is some fourth explanation for that. I'm not really sure that I fully support this, but this is something that we hear. Going to domestic courts is essential step as exhausting legal remedies before going to international court. So everyone who's looking for the international arena, legal arena to intervene must go through the domestic court. I'm not, as an Israeli lawyer, not as someone who practices in international courts, I'm not really in favor of that a cynical approach, but it exists sometimes. And if we've been asked why to keep on challenging the court, it is one of my clients, Palestinian farmer, who asked me once when we were in a group, and several Palestinians said, there is no use going to the Supreme Court. It's very hard that the enemy, your enemy, will judge you or will judge your claims. And he was looking at them. He was holding a stick. He was around 76 years old. And he said, I don't have any other court. This is the only court I have, and this is the only way I can try whether to gain my land back or at least tell my kids that I fought for my land. And these strong words that goes with me still helped me to read this book in an optimistic yet a realistic point of view. So thank you for the book and thank you for this invitation.
Thank you so much, Shlomi, for your presentation and for, I think, this important reality check as to, we can be cynical or skeptical or not really hopeful about where the court's jurisprudence is going and how it is using or misusing international law, but it is the only court that is available or the one that is available. And it's still important to use it in a way. Now, last but not least, I want to give the floor to you, Liron, to comment specifically on aspects of the court jurisprudence on the conduct of hostilities.
Thank you very much for the invitation, Emily. And this is an opportunity for me to express my deep appreciation for Professor Dave Kretzmer, both as a scholar and as a mensch, as we say. My late mother used to say that people in mountains are the opposites. A mountain, the closer you get, it looks bigger. But people, even great people, when you come closer, they look smaller. So I think my mother usually was right, but I can testify in Dave's case that sometimes there are exceptions. So congratulations, Dave and Yäel, for the accomplishment of this book. From the two chapters I read very closely, the one on house demolitions and on administrative detentions, your work is very comprehensive and accurate, and even when critical and when I do not agree with the criticism, it is always reasoned and more importantly, fair. So perhaps I should have begun with a caveat. I guess I was invited as counsel for the defense, but almost 10 years have passed since I finished my last position as head of international law in the IDF. So I'm in my personal capacity, which is my only capacity in this context. I will talk today very briefly on 4 issues. The first one, which Shlomi has indeed trespassed already a little bit, is actually the last addition of the Supreme Court to the question of security measures, the question of search warrants in premises, a judgment given just in September 1, and I guess The next edition, Dave and Yael, you'll have to get it in. So I think actually I'm thankful for Shlomi for trespassing, because now you'll see you can look at the half part of the glass or the empty one. So this will be the first issue, and then I will speak about administrative detention, thirdly about house demolition, and lastly some general thoughts I have on the title of the book, Occupation and Justice. So to the question of searches, as Shlomi has described, you know, you can look at the judgment and say, well, the court decided that there's no need for a prior judicial warrant for searches in Palestinian houses, and this is different from the rules which apply in Israel or to Israelis in the territories. But you can look at other aspects. For instance, the court actually forced the military to expose its internal instructions on searches. And there are important things that now the military is obliged publicly. First, that there will be a prior suspicion of terrorist activity in order to make a search, with a specific prohibition on searching as a punitive measure, for instance. There is also a demand in the instructions for high-level approval. If it's not immediately after a terrorist attack, it has to be a brigade commander, a level of colonel that approved the search. And thirdly, the court more than hinted that it's not enough that these rules would be in internal military instructions. They should be probably in military legislation, which is at least public. So this is the half full part of the glass. And maybe another example of what Dave has already mentioned, the shadow of the court, the effect of the court, even in cases where prima facie the appeal was denied, it doesn't mean that changes are not made. So going to administrative detention, first point would be that it's legal under IHL. I mean, unlike other things we have talked about, there's actually no question it is legal, of course, under certain conditions under IHL. And I think on the procedural conditions, there could be no real argument that Israel does apply these conditions. And now very often I hear that administrative detention is used as a political tool against political leaders. In my experience, and of course it's a limited experience of seeing only a few cases during a few years, some years ago, but I can tell you I never saw a case where people were detained for their political views. Even when there were persons with overt political activity, they were arrested for their covert activity, which was not political at all. I think the biggest problem with administrative detention is the problem of secret evidence. And the Supreme Court itself said, I mean, a defense counsel in these cases, it's very frustrating. It's like walking in the dark. There are some ways to mitigate it. One, which was already accepted years ago, is actually exposing the military judge to the raw intelligence, not just a summary of the intelligence made by a security officer, which of course, even if they try to be fair, they have their own angle. And the second suggestion, which is a suggestion, there's a bill, and we support it. And here it's not just me personal, that's an exception. That's the position of the Israel Democracy Institute, which I'm involved with today, is to introduce the institution of special advocates. Because a judge, as hard as he tries, it's not easy to be also a judge and the counsel for the defense. So the idea is that these special advocates would have a security clearance and access to the whole of the privilege information and could really claim from the point of view of the detainee. I think it's a good idea. Another big question about the administrative detention is, are there too many? Because of course, even if administrative detention is allowed, there's a question of using it only on the right cases. And again, it's very hard to say, well, how many cases would be reasonable? I mean, it's also, and I would say that one factor should be taken into account, and this is the correlation between the security situation and the detention. You can see over the years that the worse the security condition is, the more terrorist attacks there are more administrative detention. So it's not perfect, but it is some evidence that it's not completely arbitrary, at least. And again, the shadow of the court is here also important, because the knowledge that each and every case can go not just through a military court of first instance, not just into a military court of appeal, but eventually into the Supreme Court, with the whole raw intelligence being brought before the court, has an effect on the strength of cases being forwarded in the beginning. And the last point about administrative detention is, I want to ask, is it really administrative? I would claim that the role of the military commander, which signs the warrant, is actually more symbolic and minimal. There is both legal advisors screening in advance the cases before they come to the military commander, and after the fact, judicial scrutiny, which is very in-depth. So I think actually it's not a good name. It would be more accurate to call it preventive detention. Doesn't mean it doesn't have problems, but it's not really administrative detention. A few words about house demolition. Indeed, problematic, even very problematic. I've written a policy paper on collective punishment and security measures, unfortunately not mentioned in the book, perhaps because it's in Hebrew, but there is an English abstract. And I really tried both to have a definition of collective punishment and to differentiate between collective punishment, collective harm, and collateral damage, which are all relevant in the situation of security measures. I think that sometimes the term collective punishment is used too hastily. For instance, 2 weeks ago, after the escape of a few prisoners from Palestinian Islamic Jihad from the prison in Israel, Haaretz had an editorial calling the moving of prisoners from the same organization to different prisons collective punishment. So I would think this is a reasonable and legitimate security measure. But when it comes to house demolition, I really have no defense. I think they are different. They should stop immediately. Indeed, there is a special problem of deterring suicide bombers, but it cannot justify punishing family members of terrorists who are not involved in the attacks. I've made my opinion public on this matter a few times in a few op-eds and also a opinion video. If someone is interested, I can send the links. Again, it's in Hebrew. And lastly, I want to dwell a little on the title of the book, The Occupation of Justice. Maybe Dave could clarify if the title intended to be ironic, but I will treat it quite seriously. Again, you can dwell on the theory and the connection between legitimacy and its importance to the perception of justice. And here we have a problem because in occupation, the legitimacy is external. It's an international law. It does not drive or build on the political participation of the population. and this is an intrinsic problem we cannot solve. But I actually want to tell two stories on the practice, not on the theory on this. And the first is a personal story. Between the second half of 2002 and first half of 2003, I sat as a judge in the military court on cases of administrative detention in the Ksiot prison, way far in the south desert of Israel. So I've dedicated long hours to examine the raw intelligence I just mentioned, and usually get out of there very late at night, driving in complete darkness through the desert. Sometimes the moon would help me a little bit. So I had quite a few hours to reflect. And I had done my best. But did it make any difference? Now my feeling was that no one really cares. I mean, the detainees themselves had no trust in me, in my judgment. The lawyers just wanted to go home. The court clerks and interpreters also just wanted the day to end and this too meticulous judge to go home and stop bothering them. So, knowing all that, still the next time I came, I did exactly the same. Okay, that's my personal story. And last is a story about, here it's a hearsay, but from a reliable source. It's about Judge Shoham, who was a military judge and later a judge in the Supreme Court in Israel. And this is from the first Intifada. And one day his car enters the court premises and it is bashed and smashed by rocks being thrown at it. And the lawyers stand outside the court, you know, and they look at his car and they telling them, well, I have to find some excuse to postpone my case to another day. It's not good that my client who just throws stones would be judged before a judge that was just exposed to stones thrown at his car. Okay, and someone told them, well, you have nothing to worry. You know, I know him. He would be just like in every other day. And he was not a lenient judge, I have to say, but that's exactly what happened. Judge Shoham entered the courtroom. His face was poker face. You didn't see anything. Everything went as normal and with no difference. So being more general, I think there are many decent people in the military justice system and also in the Israeli legal system generally trying to make, trying to be fair in very hard and perhaps even impossible situation. They cannot cure the basic injustice of the situation, but I am sure things would have been much worse if they were not there. Thank you.
Well, thank you so much also for sharing, you know, these personal stories at the end. Now I want to give David and Yäel the opportunity to tackle some of the many points and comments that have been raised. And then we already have a few questions in the chat. David or Yäel, and Yutaka wants to say something. No, you're on mute. You're on mute.
Sorry, I just wanted to, just to explain about my question about Article 43. My question to David and Yäel is that why the Israeli Supreme Court has not actually interpreted customary law equivalent of Article 64 of the Geneva Convention, Geneva's Civilians Convention, when it comes to Article 43, so as to perhaps, to prevent any such wider notion of the, ordre public et la vie, the public order and safety in conjunction with the empêchement non absolute or military necessity exception. That's something that I wanted to ask about, but yes, thank you.
No, thanks. So yeah, David.
Okay, thank you very much, and thank you to all the commentators on your very interesting and I would say insightful comments. And thank you for some of the personal things that you said about me. If I just may make one remark to Shlomi, if I may, in public, I think he said that he studied human rights with me. Well, if I have some gratification as a teacher of human rights, is when I see lawyers like Shlomi taking the little that they learn from me and learning a lot more and fighting for human rights where it really matters. Now, let me start from the end, the occupation of justice. Liron says, what is the book? And I have a problem because when we want to translate the title into Hebrew, we can't do it because the term occupation has two meanings. The one is the occupation that we are talking about, belligerent occupation. But occupation is also a vocation, what judges do. And so I chose this title originally because I did think that while the occupation has overtaken Israeli society, has become the dominant feature of Israeli society, has made a deterioration in every aspect of Israeli society and Israeli democracy, so that I do not believe that Israel can any longer, after 50 years of occupation, be called a democracy. The occupation also took over the Supreme Court from a court which was quite a liberal court. It became a court which, as Shlomi said, and as we point out in our book, has largely contributed to the maintenance of the occupation. So justice has also been occupied, not only the territories. That was the notion. Now, of course, Liron is not going to agree with me. He will say that is the one half of the glass, but it's a very important part of the glass. And so let me then go in order, and I'll try to just mention a few points and then leave the rest to Yäel, who probably can deal with them much better than I can. The first point is Yutaka's point about Article 43. Well, yes, when the Supreme Court first dealt with questions from the occupied territory, it was very concerned with the distinction between customary and treaty international law. And it decided very early on that the Hague regulations were part of customary international law, which would be applied by Israel's domestic courts. Whether it decided, rightly or wrongly, I think wrongly, but it decided that at that stage, at least, the Fourth Geneva Convention was not part of customary international law. So the court then turned immediately to Article 43 of the Hague regulations and just continued along that line for the last 50 years and adopted what Eyal Ben-Benisti wrote in his book, and that Emily mentioned, that Article 43 has become the mini constitution of occupation. Now, of course, later on, Shlomi and some of his colleagues argued, and I think quite correctly, that at this stage of the day, certainly the whole of the Fourth Geneva Convention is part of customary international law, but the court just brushed it aside and wasn't even prepared to deal with the question by saying, yes, but we deal with these questions anyhow. So I think that is the answer to your question. But I think that your comments on Article 43 go much deeper. And what Yäel and I show in the book is how, in our mind, the court has perverted the use of Article 43, which is supposed to place restrictions on the occupying power, and has largely used it in order to justify measures which I do not think then can be justified under Article 43. First of all, by widening the notion of what is the benefit of the local population, including the settlers among the population, but also widening the very notion of the benefit. If the commander in court can show some ostensible benefit for the population of the occupied territories of his actions, even if he did not consider them in the first place, the court will say, well, it was done for the good of the local population, even though the dominant aim was clearly a political aim or the settlement. So I think you've touched a very, very important point. Perhaps Yäel would want to say a few words more about it. When you come to the question of the relationship between occupation and hostilities, yes, I think that this is a major question, and the court has not always resolved it. I think Shlomi mentioned the case of the early warning cases, that you have to give the early warning to a person, as it were, before they come to arrest him. Well, the original case came during hostilities, where the argument was that the IDF was using Palestinians as human shields. The army immediately said, no, 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 that is illegal. We're not allowing that. By the time the case came to court, the hostilities were over, and then they had to deal with the case. Well, can you send a Palestinian to warn people that they're about to be arrested? And it wasn't clear whether they're dealing with the law of hostilities or the law of occupation. So it's an unresolved question. As far as Shlomi goes, look, Shlomi, I don't think that we have many arguments. It is quite clear in my mind that the court has contributed a major feature, I would say, or a major part in legitimizing and maintaining the occupation. I wrote that in the first edition. We repeated it in the second edition. On the other hand, you have to ask, well, what would have happened if the court would have said from the beginning, this has got nothing to do with us. We're not exercising judicial review over the occupied territories. Would the occupation have ended earlier? I was naive enough to think when I wrote the first edition that possibly it would have undermined the legitimacy of the occupation in the eyes of Israeli elites earlier than the first Intifada. But I think I was naive. As I see the Israeli population today, that wouldn't have happened. So you would have just had raw power, totally unmitigated power of the military without your ever being able to get the kind of remedy that you admit that sometimes you do get for your clients in court. So the court, now let's face it, the court could not have ended the occupation. That is not the role of the court. It's not something that the court can do. And another thing that we have to understand, that from our point of view, from a critical point of view, the court has backed down and shown deference to the Israeli government. But as seen in right-wing circles in Israel, and they are the dominant force in Israeli politics today, the court is a pro-Palestinian institution to the extent that the court is under a tremendous attack. And it's under attack from parties which were the main parties in the previous government and major parties in the present government. And the court, as Yäel pointed out, is a political institution. It's a domestic court. It's operating in a certain political scene. And it seems to me that if the court would have done much more, there would have been mechanisms, I don't know what, but political mechanisms to restrict the jurisdiction of the court and make sure that it doesn't interfere at all. So it was playing a very fine game. As far as the international influence, Yäel is going to say something about that. Now, I have to mention this last case because there was a division of opinion between Shlomi and Liron on this case. And I am not so much interested in the legalities of how they contain the authorities in this case. And that's the half of the cup that Liron mentioned. What bothered me in this case, and I put it in writing, was that the court fundamentally, it's an embarrassing case in my mind. There are some cases of the court which are embarrassing because the court fundamentally, it justified arguments that the system that applies in practice in the occupied territories is a system of apartheid. For when you say that the government, all the rulers or whatever have decided to impose two different legal regimes on two populations in the same territory, where the division is on national grounds or ethnic grounds, and you justify a difference because different systems of law apply, if that's not apartheid, I'm not sure what apartheid is. So it's an embarrassing, and there are some other embarrassing cases of the court, but I won't mention them. I'd like to leave some room for Yäel to take over.
Thanks a lot, David, for covering so much ground in your response. I'm quite impressed. Yäel, your turn.
Yeah. Okay. So I'm not on mute, right? Am I? Okay, I'm not on mute.
No, you're not.
Okay, so first, with regard to what Yutaka said about the inclusion of Israelis within the local population, without detracting from the problematic nature of everything that's been said, I think one of the issues, and we come across that in other contexts as well, is that had the matter been, let's put it that way, regarding the Israelis as part of the local population for the purposes of Article 43 is not in itself necessarily detrimental. The question is, what does that mean? Because being part of the local population does not give anybody absolute rights. Who better knows that than the Palestinians? If within the fact that there are various people living within the territory, all regarded as local population, in the case where there's conflict between the interests and rights of the two populations, that conflict had been resolved in accordance with international law, then there might not have been necessarily an issue. Now, the problem is that, and let's just recall that article that the Hague regulations provide the occupying power with power a lot, and provide less protection than the Geneva Convention does. So there's grounds for limiting the rights of Israelis, even if they are regarded as part of the local population, and when their rights, or where their interests rather, conflict with those of the Palestinians, the question of who should have had priority is one that the court could have resolved in a different manner than it has. Now, the thing is that essentially all Israeli interests are in conflict with Palestinian interests. I can't think of any, at least not cases that arrived before the court, where whether Israelis would have certain rights or not had absolutely nothing to do with with how that would affect Palestinians. Now, the fact is that the courts, when cases of conflict between Israelis and Palestinians came before the court, and whether it's Article 43 or the separation barrier sometimes under different legal regimes, the balance, not knowing the specifics of a case, we can usually tell you whose interests are going to prevail. That's not in the law, that's in the practice of the courts. So just the inclusion of them as local population is not necessarily the last word. Now, again, why do so many decisions of the court lean the way they do? That's the story that I referred to earlier. Something about what Shlomi said about the role of international criminal proceedings as a potential deterrent and how the court deals with that. I think the examples that you gave are good examples of cases where the court prevented the introduction of some practice or a policy so that Israelis would not be in violation of international criminal law or minimize the risk or something like that. But there's another element to this. And what do we do with those practices that are considered to be in violation of international law and already exist and have been taking place for 50 years? House demolitions would be an excellent example, or deportation, which is not exactly being practiced now. And there, the court is in a different position. It's not in a position to, if it says, well, you cannot demolish houses anymore because that's unlawful under international law and constitutes a criminal offense, then it might prevent the next demolition, and it might prevent the next military commander or whoever gives the order from committing the crime. But at the same time, it acknowledges that everything that has been done until now was a criminal offense, and everybody involved in it is involved in crime, including the judges themselves having upheld those practices. So how international criminal law acts as a deterrent kind of depends on whether this is a new policy that somebody is attempting to introduce, or whether we're looking at existing policies that have already taken place. With a couple of things for Liron. First of all, with regard to to your article, indeed, we have failed in being entirely inclusive and comprehensive. If it's any consolation, then your article about collective punishment features extensively in a recent article of mine that was published in the International Review of the Red Cross about family visits to Palestinian prisoners. Kind of making up for it, I hope. With regard to administrative detention, I think this is one chapter where I think we did not point to a clear violation of international law. There's different types of administrative detention, administrative in the sense that they're not governed by a judge's warrant. And in fact, I would not call them preventive detentions, because one of the problems is detention during hostilities, the Malab case, where preventive is not the case. That was the whole point. It's not at all clear what the legal base for that kind of detention was, whether under international law or even under the security legislation. But I think going beyond all the constraints that the court has placed in terms of the administration, and this is something that we also see, we used to see in deportations. The bottom line is, as you say, the recourse to confidential evidence, and the fact that essentially what the state says is trust us on this one, and the court says, okay, we trust you. Because it's true that the court does get to see some of the evidence that the counsel for the petitioners don't, but the court, without that counsel, the court has absolutely no means of questioning the credibility and of that information. So, and the whole point of a court is, no, you don't trust any party on that one. It's at least not in the adversarial system that we have. I mean, there's other ways of doing it. So the whole system doesn't work as it is supposed to. And in fact, this is something we don't put in the book, and I'm saying this without having consulted with Dave. So I'm saying it definitely, like everything else for that matter, on my own behalf, is that the fact that the court has never overturned a decision of detention. The state has always been right, has never failed at all, has never made a mistake. Isn't that a little bit suspicious? But we don't have any means of checking this, and the court does not want to take the risk of getting a false positive or saying, oh no, here the state made a mistake, this person needs to be released, and then if something happens, who's going to be blamed for that? The court is going to be. So the court will not take that risk. But to assume that because of all these administrative arrangements, the system works well is, I think, taking it one step too far. And finally, with regard to the Hamid case, not so much about the content, and I entirely agree with what they've said about it, just an anecdote on our part. We actually concluded the manuscript at the end of May of 2020, last year, and we sent it to the publisher. And then the decision on the regularization law was published. And we found ourselves thinking, do we need to reconsider some of our chapters? Because for those who are not familiar, this is a decision in which the court found that it struck down legislation as unconstitutional, and that legislation essentially required the military commander, under certain circumstances, to transfer private Palestinian lands to in order to establish settlements on them. And it required the military commander. It didn't even leave the military commander under discretion. And the court said, and it was not the first time, it was the second time, it was extremely significant in this Ziyada case, that the protected persons, the Palestinians, are in an inherently inferior position to that of the Israeli settlers, who are full and equal citizens in the state of Israel. And we were wondering whether there's new wind blowing through the court, and maybe there was a new approach in which the court is willing to give concrete expression to the inherent balance between Israeli settlers and Palestinian residents. And I'm very glad that we were careful to say, who knows? Because the simplicity with which the court in the Hamid case said, there's different arrangements because there's different law, which I think is a little bit of a vicious circle, is frankly scary. It's not a continuation of Ziyada. It goes, 180 degrees. So thank you, Shlomi, for maintaining optimism. I have, the more we speak about it, the less I understand how, but go for it. People need your optimism. Thank you.
No, thank you so much. Yeah, again, very comprehensive response to a lot of different topics. We have about 15 minutes for Q&A, so I don't guarantee to everybody who did ask a question that we'll get to it, but we'll try, I promise. The first question, I guess, alludes to what Shlomi said about whose land is it and which people are we talking about, but Does one of you, or maybe Shlomi first, have anything or any thought to share about the recent events and also judicial sort of saga that has taken place with regards to the houses in Sheikh Jarrah in East Jerusalem, for those of you not familiar with the neighborhood, and legal dispute around property rights of Palestinians who've been living in the houses, and the Supreme Court, I think, also decision on the matter.
Shlomi, do you want to say something about it? Yeah, Shlomi is involved in the.
No, actually, I'm not involved in Sheikh Jarrah, and this is something that I said. Well, it's way too complicated, but it is very complicated, the Sheikh Jarrah. But I'll not go into details with everything. But what is very important is the double standard of what I see the government of Israel. Sheikh Jarrah, according to Israeli eyes and Israeli point of view, was annexed in 1969 to Israel, and therefore is subject not to the law of occupation, but rather to Israeli domestic rules, regulations, and legal standards. The discriminatory nature of several legal arrangements existing in Israel that allowing so-called returning back lands that was owned by Jewish Israelis prior to 67 or prior to 48 Israelis, while at the same time does not allow the returning back property of Palestinians that was described as absentees, is another aspect of this, whose land, whose people, and all these subcategories of groups and privileges. But what I meant about the double standard is that on the one hand, the government and the military, not the military, sorry, and the Attorney General said that this is a private conflict between the owners, the original owners from the 19th century, and the people who lives there as part of the Jordanian mechanism. And therefore, the Attorney General refused to file their brief to the Supreme Court to view as an overall brief on the entire issue. On the other hand, Israeli officials were trying to persuade American diplomats to put pressure on Palestinians to accept some compromise that the Supreme Court was suggesting. So if it's something only on a private issue, so why getting into all this diplomatic intercourse and discourse between all these 3 or 4 or 5 nations involved? If it is something with a much more broader aspect, and it has a broader aspect, and it is not only, watching it only as a private conflict between 2 entities and arguing about ownership, it's something that is turning a blind eye to reality and turning a blind eye to what might be the effect of that. This case is still under deliberation in the Supreme Court. There was a very, very in-depth legal opinion by Dr. Ronit Levin regarding the status of these land issues all over, and it is very far from reaching a decision. But I will depart from your question to another question that was addressed to us. But what is the position of the land? What is the regime that governing the land? And it's really hard to tell. According to the Supreme Court, they view it as a part that under belligerent occupation, though the word occupation per se is really hard for some of the court judges, the Supreme Court judges to say. So they're using some very old wording for that. But while, as Professor Rai mentioned, occupation is not permanent. It's something that should be interim, but after 53 years, we view it as more and more permanent or more and more flexible and that will remain this, in the area. And one of this very funny wording that was in the Ziada case that Yael mentioned was what is permanent and what is interim. And there is things and there are arrangements that are interim permanent or permanent interim, and there are real interim and there is a real permanent, and no one really understands. And I think Professor Amichai Cohen in his case comment regarding Ziada really put his hands on the problem. Is you cannot deal with 53 years of occupation with the law of occupation solely. It is impossible. It is very limited. You're trying to manipulate. You're trying to being very acrobatic, but it cannot be done. So these are my 2 cents.
Thank you so much, Shlomi. Yeah, David, you want to add something?
If I could add to that, and I'm going to go back to what I said at the very beginning. It's not only a question of the occupation going on for 50 years. The question is the actual disparity between the political attitudes of the governments of Israel and the formal legal arrangements which are ostensibly still applied by the Supreme Court. In every single case, all the judges say, they go over the legal rules and then they say the laws that apply are what is known in Hebrew as tfichatzah loch batit, but when they translate it into English, they say belligerent occupation. They don't use the word kibush, but they do use the English belligerent occupation. So ostensibly, that is the law that is applied, but the government does not see itself as bound by that law. And as Shlomi said, the attitude of the government, and I thought I was saying something radical when I said this 10 years ago, that the law of belligerent occupation has become a system of control over the Palestinian population, that the government regards the Palestinians as subject to the law of occupation, but the land is not occupied. So this is a new kind of Israeli invention, that you can have a control over land where the population is subject to the law of belligerent occupation, but the land is not occupied. And this creates the total disparity. And the court is in a very difficult position because, as I said, it's a political institution it's a domestic court. It's not an international court. It has to maintain its legitimacy among the Israeli population. If it does not do so, it will not only will it not be able to rule in questions on the occupied territories, it won't be able to rule in anything at all in Israel itself if it loses its legitimacy. And the court at the moment is in the danger of losing legitimacy among large sections of the Israeli population, and they are not marginal sections. So you have to take that into account, and that is the problem. Of course, the occupation of 53 years changes. And that is why I think one of the questions is the question of Sadi Kedar. How would you typify the situation now? Well, Yael and I said, well, of course, formally it's belligerent occupation, but in fact, if we have to describe the regime, it's become a regime of settler colonialism. That's how I would describe the regime.
Thank you also for being so clear. I guess we've addressed the question of Professor Kedar. So I will now turn to another one with regards to Gaza. And the question is, settlers have been evacuated voluntarily from the Gaza Strip since between the first and the second edition of the book. Does this change the legal status of Gaza compared to the West Bank and East Jerusalem? And what is your opinion on it? Do you think, the Gaza Strip is occupied or not? And does this reflect in any way in the jurisprudence of the court?
Yeah.
Okay, so no, the court hasn't said anything new about Gaza since 2006. And in 2006, it said that the status may evolve depending on fact. So it opened the door to the fact that the status may be different, but it never actually got into that. And this is, it connects with the question that Roberta asked earlier about how the court avoids the issues of policy and practices. And the court never says it doesn't really matter. We don't need to decide on the issue of whether the territory is occupied or not, because in any case, administrative law provides us with a framework that is sufficient. And most of the issues that have come to the court are about entry of Gazans into Israel or through Israel to the West Bank and elsewhere. And the court deals with that in terms of entry from occupied territory into the territory of, entry of persons into this into Israeli territory. There's policy of the government on that. And the question is whether the government is acting in accordance with its own policy. How this policy sits with international law is something that the court has avoided discussing. And it's actually interesting. There are questions where the law of occupation might be very pertinent. And for example, I mean, now with COVID-19, the question is what are Israel's obligations towards the residents of Gaza? This has not come before the courts. The only context in which it came was a demand that Israel not transfer vaccinations to Gaza until we have information about missing persons and fallen soldiers. And the court said, nobody's planning to transfer anything, so we can't give an order not to do something that the government is not planning to do. So it only dealt with this narrow issue. This has to do with the question of what comes before the court. The court doesn't deal with questions that are not before it. So as to the question of what is the status of Gaza, I'll simply slide away from that one. Opinions are divided, or actually the question under international law I'll avoid, but I think it is true that a lot of the questions can be answered on different grounds if somebody wants to answer them. But even that is not happening.
Thanks. Yeah, Liron, you wanted to add something?
Yes, thank you. Just a short remark, because I think our time is running out on the Gaza issue. My opinion is Gaza is not occupied, surprise, surprise. But what I actually wanted to say is that it is a good example that political manipulation of international law is not something limited to the Israeli side or to the Supreme Court. Because I think understanding the Gaza Strip under Hamas rule as occupied by Israel, it really defies all previous definitions in international law. And maybe this is part of the explanation why international law has such a bad name in Israel, and part of the explanation why the Supreme Court chooses not to lean its judgment on international law, but rather on Israeli constitutional law or administrative. Thanks.
Thank you. David? Do you want to add something?
Well, surprisingly, I agree with Liron on this question, although we do agree on many other things. Yäel is correct that the Supreme Court generally avoids addressing the questions, but it does have one judgment in which it said that Gaza was not occupied, and yet that Israel still maintains certain obligations towards the residents of Gaza because on humanitarian grounds and because it was an occupying power. It's not exactly clear what the basis of those obligations are. What the court was saying that to the extent that you have some control over Gaza, you cannot say that you don't have any obligations. I believe also that Gaza is not occupied for the main reasons that were provided both by Eyal Ben-Benisti and Yuval Shani. The main, as we said, the mini constitution of an occupation is Article 43 of the Hague Regulations. And the occupying power has to maintain order and public life. If the power is not capable of doing that without a major war, it cannot be regarded as an occupying power. In other words, in order for Israel to carry out Article 43, it would have to have a major war. Well, it cannot be regarded as an occupying power. And that is what Eyal Ben-Benisti said in his book. So I really would think that Israel is not an occupying power, but it does have obligations. And I do believe that because of the dependence of Gaza on Israel for many years, an independence which was largely supported and created by Israel in many extents, Israel can't wash its hands and say this is a foreign country, we don't have anything to do with it. And I do think that Israel has large things. What is the basis of that? That is a question on which there is a division of opinion.
Thank you. I'm just going to allow you to take one remark and then we'll wrap up.
quickly add that I actually concur, just like in the case of the European Court of Human Rights in the Goodies stance, I do not agree with the view that the boots on the ground is necessary, but I also think that given the huge amount of the panoply of the economic, social, and cultural rights obligations, especially under the GC4, which may be now considered as customary law, which may now include customary law concomitants on economic, social, and cultural rights affairs, such as the right to education for the children, without any effective control or capacity to exert effective control in a short time, it's very difficult to say that Israel is an occupied power. But having said that, this doesn't prevent the argument, and that's my view, that Israel also has an post-occupation obligations as being the former occupying power. Yes, as long as also it controlled the territory or the excuse me. And the blockade, the access to the territorial water, the obligations no fraud, yes. And so it's the conclusion would be very much similar to Yäel Ronen, the writing on the wall, like in a functional approach. So we can actually take into account more sort of a compartmentalized analysis of which rights are considered as still, duties are considered as still binding on the post-occupation regime, I would say. Thank you.
Thank you so much. On that note, we're going to have to wrap up. Apologies. I guess we've touched upon many of the questions asked here. If we haven't addressed them directly, apologies to those who have asked them. Very warm and sincere thanks to Yäel and David for trusting the Geneva Academy to organize this book launch, and to the three commentators for their very, very insightful remarks. I hope that you've enjoyed the conversation as much as I did, and I wish you all a good end of day.
Thank you very much, Emily.